Today's podcast is brought to you by Audible. Get a free audiobook download and 30-day free trial at washingtech.com/book. Over 180,000 titles to choose from for your iPhone, Android, Kindle, or MP3 player.
Moving the needle. Welcome to the Washingtech Policy Podcast.
Curating communications, media, and tech policy news so you don't have to. News, interviews, everything you need without the axe to grind. It's the Washingtech Policy Podcast with Joe Miller.
The FBI says it won't reinvestigate Hillary Clinton's emails. The FCC delays a vote on the set-top box rules. And Christine Farley is my guest. FBI Director James Comey doesn't want anyone to think his agency is comprised of weasels. His words, not mine. Comey appeared at a hearing before a House Judiciary Committee panel last week to explain why presidential candidate Hillary Clinton was never charged during the investigation into a private server she used as Secretary of State. Comey said the agency hasn't uncovered any additional evidence that would necessitate reopening the investigation. Matt Zapotsky has more at the Washington Post. John McKinnon at the Wall Street Journal reports the FCC has delayed a vote on the proposed rules to overhaul the set-top box marketplace. FCC Commissioner Rosenworcel, a Democrat, was the swing vote. The plan would require cable providers to make content available to set-top boxes that compete with the ones issued by cable companies. The proposed rules faced a firestorm of criticism from the cable industry and Hollywood, who claimed, among other things, that the rules would exceed the Commission's authority and violate copyright. The good news, as Harold Feld at Public Knowledge has noted, is that the proceeding is far from dead and still open for comment. Several consumer groups are crying foul about WhatsApp's recent announcement that it would begin sharing user data with its parent company, Facebook. WhatsApp has long held itself out as a secure and encrypted messaging service. Groups including the Center for Digital Democracy and Demand Progress, along with 15 other groups, sent a letter to the Federal Trade Commission last week asking the agency to investigate. Grant Gross has a story over at Computer World. 4 Republican attorneys general from Texas, Arizona, Oklahoma, and Nevada filed lawsuits against the Obama administration for its plan to transfer oversight of the Internet's domain systems from the U.S. to an international body. They are alleging violations of what they believe to be a U.S. property interest in the domain systems, that the transfer is a First Amendment violation, and that it violates the Administrative Procedure Act. Ali Breland at The Hill has the full story. Finally, the FCC released an NPRM last week which would prohibit cable companies from bullying independent content producers with clauses in their programming agreements saying that the content producers have to give the cable company the best deal and not allow anyone else to carry their content without permission from the cable company. These are known as Most Favored Nation and Alternative Distribution Method clauses. The cable industry is pushing back, but this is still an NPRM, not an official ruling, and thus it is still open for comment. Stay with us. For Washingtech Policy Podcast listeners, Audible is offering a free audiobook download with a free 30-day trial to give you the opportunity to check out their service. You can listen at the gym, in the car, or on your morning run. How about Pedigree? How Elite Students Get Elite Jobs by Lauren Rivera.
Children from families at the top of the economic hierarchy monopolize access to good schools, prestigious universities, and high-paying jobs.
You can download Pedigree free by trying audible.com. Sign up for your free audiobook and 30-day trial today at washingtech.com/book. Today we're going to be talking about how trademark law can be used to prevent the use of offensive names in commerce. Section 2A of the Lanham Act prohibits the registration of, quote, scandalous, immoral, or offensive marks. My guest today is Christine Farley, professor of law at American University Washington College of Law, where she teaches courses on intellectual property law, trademark law, international and comparative trademark law, and international intellectual property law. Please welcome Christine Farley. Professor Farley, welcome to the show.
Thank you. I'm happy to be here.
So many of us are familiar with laws like the Civil Rights Act that are specifically designed to promote diversity. But can you give us a sketch of how trademark law can help promote diversity or at least offset some of the effects of harmful speech in commerce?
Yes. It's quite surprising to most people to know that trademark law has any role to play here. But in fact, trademark law in all of its doctrines and statutory provisions does try to do good policy work. And one of the things that it does is it prohibits the registration of marks that are scandalous, immoral, or disparage people, institutions, or beliefs. Mm-hmm. And in this way, it, I think, keeps the government out of the business of putting its seal of approval on really offensive language. Mm-hmm. And it may also kind of signal to businesses what are appropriate marks that they should be in business with. Mm-hmm. It doesn't tell businesses that they can't use certain marks as trademarks, mm-hmm. But it does deny the benefits of registration to certain marks.
So they can still use them. It's just a question of, they can't register the mark. So
That's right.
What is the historical context here when it comes to the use of offensive trademarks? So what are some early examples?
Well, in the little bit of research that I've done, it looks like we have a long history of offensive trademarks in use. And, it won't surprise you that things that were tolerated 100 years ago wouldn't be tolerated now. Mm-hmm. But there is an interesting history of, kind of racialized trademarks, racialized logos. And one example that has had a lot of kind of legislative wranglings and legal wranglings is the trademark Little Sambo's for a restaurant. Mm-hmm. And that was a business who used Little Sambo's, and its visuals were very racialized, and they didn't want to stop using it, and certain municipalities made special laws to get them to stop using it. So that was something that was litigated. There's also a controversy over the trademark Crazy Horse mm-hmm. for malt liquor. Mm-hmm. And there's also been, of course, a lot of controversy over another well-known trademark, which is Aunt Jemima's. Mm-hmm. And you may know that the kind of logo for Aunt Jemima's has changed many times over the years to try to make it more acceptable. Mm-hmm. But it remains controversial.
I've tried Crazy Horse. It tastes terrible.
I can't imagine.
So, and the most famous current example of a trademark that's considered by many to be offensive is the Redskins trademark of the Washington, D.C. based football team. What is the etymology of the offensive term Redskin, and how is the dispute in that case evolved, and where does it stand now?
Well, the evidence suggests that the earliest use of Redskin was not, as most believe, to refer to color of skin, but in fact was used to refer to a bloody scalp of a Native American. Thereafter, the term then was generally accepted as a reference to Native Americans, and this lasted maybe as late as the 1960s, when research shows that really the only use of the term was use as a racial slur. All of this evidence has been submitted in the case. The case has been litigated since 1992, when the claim was first brought, and there have been several decisions. It's been all over the courts, and the latest event is actually today, where the Supreme Court denied cert in the case. When the band The Slants petitioned the Supreme Court for cert in their case, I think 5 days later, the team also petitioned for cert in their case. They wanted the Supreme Court to hear their case as a companion case, since they both involved the same question about whether this statutory provision violated the First Amendment. The Supreme Court last Thursday granted cert in the Slants case, but today it denied cert in the Redskins case. And of course, we don't know why they did that, but it could be because the Redskins' petition for cert was premature in the sense that the Court of Appeals had not decided the case. So we had a decision in the Federal Circuit Court of Appeals in the Slants case, but in the case of the Redskins, argument is scheduled in that case in the Fourth Circuit Court of Appeals on December 8th. And so because I think this case, the Slants case, will be heard by the Supreme Court not until the spring, it looks like we will have at least a hearing in the Redskins case in December. And then, it's possible to have a decision from the Fourth Circuit before the Supreme Court decides or even hears the case in the Slants. But it's also, of course, possible that the Fourth Circuit may wait and see what the Supreme Court does.
So let's talk about the harmful effects. What are some of those specific harmful effects that these slurs have been shown to have on the public?
Well, of course, different populations will react differently, and there's some understanding of this in the law, so that when it comes to scandalous and immoral marks, the law is paying attention to those marks which would be offensive to a substantial composite of the general public. Mm-hmm. But when it comes to disparaging marks, the law is concerned with how that referenced group responds to the marks. Mm-hmm. And in the law, we don't have a lot of evidence of this, but one of the places that I've seen evidence of this is in the Redskins case. When the case was first appealed to the Supreme Court, in the petition for cert, there was an amicus brief filed by the Association of Psychologists, mm-hmm. who cited studies that were done on the Native American population, and it was quite depressing to see how much correlation there was between their poverty and suicide rates and really, the suffering of that community, and the way they continued to be used as mascots and, have to deal with these racial slurs in trademarks and in sports. And the argument that was put forward is that these marks really have a harmful effect on their self-esteem, a really damaging effect on their self-esteem, and really should be discontinued.
And was it a court, or was it the actual statute that requires them to assess the effects on the group as opposed to the general public?
Oh, that's a really good question. It's not the statute. The statute just prohibits marks that are disparaging, or marks that may disparage, in fact. And it has been the Trademark Office Tribunal, the TTAB, which came up with the test that we should look at a substantial composite of the referenced group. That test was adopted by the Federal Circuit Court of Appeals, and that test has been adopted in the D.C. Circuit and now by the Eastern District of Virginia. But there's no magic in that test. That's just a judge-made test. So in this question that's looks like it will be heard by the Supreme Court about whether the statute is constitutional, mm-hmm. there's a lot of room to devise a different way of addressing this statutory prohibition. It doesn't have to be in the way that it's been applied.
Right, because wouldn't it make more sense to look at the general public as opposed to how it affects just that specific group?
Well, I think the idea is that if you look at the specific group, you get away from the problem where the majority doesn't have a sense of the harm to a minority, mm-hmm. and I think that's admirable. But the argument that's being made in these cases that are up on appeal now is that the statute is unconstitutional because it's a viewpoint discrimination, mm-hmm. and I wonder if you didn't kind of view it in a more objective manner, you might save it from that constitutional claim.
Right.
So that if you just said, look, this word is in the dictionary and all the dictionaries say this is a racial slur, so we don't have to survey any particular population. We're just going to say no to that word. That word can't be registered.
I see. So let's zoom out and put this into international perspective. So we have this Lanham Act, Section 2A, that's very narrow and only applies to registrations. It's not a prohibition on use or even using the courts to protect works that may be disparaging. But how does this compare to protections against offensive speech embedded in trademark laws in other countries?
I think what we do in U.S. law is quite comparable to what's being done in other countries. I'm aware of several other countries that have a provision prohibiting the registration of a mark which is either immoral or contrary to public order. And so I think the idea that you would offend the public is captured by that. And there have been cases in other countries, such as a case not too long ago in the UK involving a trademark for the word Paki, which is short for Pakistani and also allegedly a racial slur. So this law operates basically very similar in other places. And treaties from 100 years ago kind of give countries this space to regulate trademarks in this way. So I think it's a long-standing feature in these other countries as well. We've had a prohibition in our statutory law against immoral and scandalous marks since 1905. And we've had a prohibition on the registration of disparaging marks since 1947.
Mm-hmm. Christine, it's been a privilege having you on the show, so thanks once again for joining me. I just want to ask you a few more questions, and then we'll close. Sound like a plan?
Yes.
All right. The focus of this podcast is tech policy, but it also focuses on helping tech policy professionals be more productive and finding meaning and purpose in their work. Tell us, Christine, what are some habits, tactics, and apps that you implement to come as close as possible to your full potential?
Okay, I'm going to go full Luddite on you here, especially with your audience. I've been reading a lot of research about, because I'm an educator, about reading things online and taking notes on laptops. And it seems to suggest that there is a kind of really a neurological value to touching paper
right.
and, reading from a book and to writing notes. And so of course, I do most of my work online like everybody else, but every now and then I do try to kind of print something out and write in the margins or handwrite something. And I find kind of shaking it up like that helps, and I encourage my students to do the same. The other Luddite habit that I've recently made for myself, which I think has been helpful, is to just prohibit for myself the use of certain apps, certain sites, certain platforms, certain devices during certain times. So I can waste all of my time on Twitter, and so I have to relegate it to certain times of the day. I try not to have my cell phone out if I'm having a meal with anyone, or if I'm trying to have a quality time with another human being. So I think just finding the space and cabining it, and not, kind of living your whole life through the screen is what I'm trying to do.
I've found that reading actual books and taking actual notes on paper is very, very helpful for that active learning. It really sort of sinks in and actually makes it a little more interesting. I find this distractions come up when if I'm reading an ebook, I can just go into Facebook right there. But if I have a book, right. I have to put down the book and get the device. And then there's also as far as the time management, there's this Pomodoro method that I've been trying out, where you focus for certain blocks of time, on that one thing, and then take a break and then come back to it. So that's been working out rather well.
Yeah.
But can you tell us the name of a book that you're recommending these days and why?
Sure. So I read a lot of nonfiction, and I recently read this book as an educator, but I think it would have interest to anybody kind of in the professional world. It's called Pedigree: How Elite Students Get Elite Jobs by Lauren Rivera. And it's a really interesting study by a business school professor of how the very top employers, that is by salary, hire their entry-level people, how they recruit them, how they interview them, how they evaluate them. And this woman does a bunch of different studies, like with fake resumes and things like that, to elicit from employers, how they're evaluating people. But she also embeds herself in I think it's a consulting firm in the recruiting process on elite campuses. Mm-hmm. And it's just really enlightening to see how, in fact, I think there's something common in all areas where people just try to replicate themselves. People become really comfortable with what they know, mm-hmm. and how implicit bias seeps in.
Right.
And I think it's it's eye-opening to somebody who's on the job market to see how they may be perceived, mm-hmm. and it's eye-opening to someone who's doing hiring to see how they may unwittingly be just kind of replicating a status quo and keeping, the very top at the top and closing the door behind them.
Does it give any specific tips on hacking that by implementing what some of the more elite students do?
I wish. The only thing which stands out as an exception is when non-elite people get to elite places and how they then have the ability to kind of open the door and bring other people in. So when you've got somebody, for instance, who's a graduate of a state school in one of these, top law firms, mm-hmm. and they, fight for some candidates from state schools, mm-hmm. That opens the door a little bit. But it was rather a depressing book.
There's two prongs they have to meet there. First, they have to get up there, and then they have to, lend a hand. And the second part is invariably not the case, unfortunately.
Right.
But thanks again.
There may be political cost with that.
Right, exactly. But thanks again, Professor Farley, for joining me. Do you have any final ideas you'd like to leave with the audience before we close? And where can folks find you online?
Folks can find me on Twitter at @prof_Farley, or my webpage at American University, Washington College of Law. And the thought I'd like to leave you with, Joe, and maybe your audience, is there are interesting things happening in domain names, in the new generic top-level domain names with these new rights protection mechanisms. And I'm really trying to pour some research into that. And I would love to see you cover those issues on a future show.
You've been listening to Professor Christine Farley, Professor of Law at American University, Washington College of Law. Christine, thanks for joining me.
Thanks, Joe. It's been a pleasure.
That concludes episode 58 of the podcast. Thanks so much to all of you for listening. If you like what we do here, we'd love to hear from you. Please take a moment and head over to iTunes and give it a review. It helps others know what they can expect from the show and helps us out tremendously. Thanks again to all of you for listening, and I will see you back here next week. Take care.
Thanks for listening to the Washing Tech Policy Podcast. You've been briefed.